we need Mr. Clark, I believe. There we go. I think we have our full allocation for this afternoon's 11 o'clock docket. Mr. Glossier, did I pronounce that correctly?
It's Glauser, Your Honor.
Glauser, thank you.
Yes.
And did you wish to reserve time for rebuttal?
Yes, 4 minutes, Your Honor.
Okay, I will do my best to let you know that when you're arriving at your 16-minute mark, but in the interest of complete disclosure, I have failed the last two cases to make a timely notice. So pretty soon I'm going to say there are no representations from me at all that you can rely upon, but I will try once more to get it right. With that being said, we are ready to go.
Thank you, Your Honor. May it please the court, my name is Charles Glauser for the appellant, AMP7 Palm Harbor LLC. And for ease of discussion, I'll refer to it as AMP as the appellant. The appellant contracted with the appellees to provide security camera and electrical work at a marina in Charlotte County. The work was actually quite extensive and involved the installation of 20 cameras, as well as running electrical work, conduit and wires for upwards of 300 feet to one of the actual security cameras. The project progressed and unfortunately deteriorated, as some of these matters do, and ultimately resulted in a dispute over the scope of the project, as well as the assertion of liens and the filing of a lien foreclosure, mechanics lien foreclosure lawsuit, breach of contract, and a third count for quantum merit by the appellee Computer Guru. The case actually proceeded to trial, and Judge Porter entered a final judgment, making very specific findings with regard to the untimeliness of the mechanics lien, the amounts that were added to the actual lien itself, and the trial court dismissed the lien foreclosure lawsuit and discharged the lien, but in the end actually did award damages in favor of both parties on a contractual basis. The appellant today believes that the trial court made two mistakes. The first is that at the close of the plaintiff's case, the trial court mistakenly placed the burden upon the defendant to on a motion for involuntary dismissal. We timely made a motion for involuntary dismissal based on the fact that the substantial work that was done was actually unlicensed electrical work completed by the appellees. As such, the argument was made that there was no recovery in law or in equity for the appellee, and therefore the appellee had failed to meet its burden in its case in chief and was entitled to no recovery at all under any three of its accounts.
Did not include any money for the unlicensed work, right?
Yes, it did. I do believe it did, Your Honor. The original scope of the project contemplated electrical work to all 20 of the security cameras. Not one could have been installed without the electrical work running to the 20 cameras. And indeed, it cannot be lost that there was a peninsula.
You're talking about whether it goes to the essence of the contract. You're talking about whether there was actual unlicensed work that AMP had to pay for.
Well, the essence of the contract goes to whether the electrical work can be severed from the rest of the work, which we do not believe it can. It was not.
So you just made a distinction between the two works. So was any work that you're contending could be considered as unlicensed electrical work? Did the award include any payment for that work?
The total amount of the contract according to the trial court was $45,000 roughly, and I believe payments were. Oh, I'm sorry. The total amount of the contract was $60,000. The defendant paid $45,000 roughly, so there was a $15,000 shortfall according to the trial court. And so, yes, we do contend that work was paid for the unlicensed electrical work. In fact, that was a substantial part of the actual work that was done, because really and truly, the Cat5, the copper wiring, the conduit, everything that had to be installed, other than just putting in these cameras, which of course, putting a camera up on the wall doesn't do any good if you don't have Cat4, Cat6, or electrical service to them. That really the installation of the cameras was a nominal part of this. The majority of the actual contract was providing all this service to these security cameras sprinkled around the actual marina itself.
Mr. Glosser?
Yes.
Did Guru have the opportunity to present its own expert to rebut your expert's testimony regarding what required an electrical license or not?
They had a expert designated, and he was deposed, I believe it was 3 days before the trial. And they withdrew his name from the trial witness list the day of the trial. So yes, I would say they had the opportunity. They even designated someone. We don't believe that he had the qualifications to testify as to that, but we do believe they had every opportunity, and they did not, of course.
But that's all something that they could have done at trial if they had known that you were going to make that argument for the first time at the motion for involuntary dismissal stage, right?
Yes, Your Honor, that is an opportunity they had.
Okay, so and theoretically they didn't do that because until you made that argument at that stage, and we can't answer it from the record, obviously, but maybe they didn't make that decision because as far as they knew, it wasn't an issue until that involuntary dismissal stage.
Well, I believe it was actually briefed by both sides, Your Honor, in the motion for the Daubert motion that they filed. And as you can see on the argument in the trial, at the motion for involuntary dismissal stage of the case, counsel for the appellee actually had all the case law already. She knew that this was an issue that was being raised. And again, they had an opportunity to present this evidence because there was two issues. The first was an order by the, I believe it's the Florida Electrical Contractors Licensing Board. We had an initial issue about whether that order would be admissible or judicially noticed at the very beginning of the trial. And we argued about that issue. And the trial court did take judicial notice of that issue. Of course, that order found that all the work relating to the installation of the security cameras, the installation of the Cat5, the Cat6, would have to be done by an a licensed person in the state of Florida. And that is by the board that actually does issue these licenses. And then the second question was, unfortunately, our expert witness, Scott Hudson, was accidentally unavailable at the very last minute. And so the question also became, as a preliminary issue at the trial, whether his actual deposition testimony would be admissible. And so we argued on those 2 points extensively about the applicability of the National Electrical Code, as well as whether this needed to be licensed work done by Computer Guru and by Mr. O'Toole. So I would say, Your Honor, that they had ample notice to provide a witness in rebuttal. And I would also note that
so even though this wasn't one of your affirmative defenses.
That is correct, Your Honor.
Your position is that they certainly weren't blindsided by this and knew that it would be if it's not one of your affirmative defenses, then how can it come up at trial? I know that your position would be that it's part of their prima facie case. So
yes, Your Honor. We would say that they, of course, had to produce some sort of enforceable contract.
Well, that's not what the case law says, and I want to make this a very clear distinction. And maybe it's an incorrect distinction, but to establish a prima facie case, you have to have a valid contract. And there's a distinction, I think, between a valid contract and an enforceable contract, because if you don't have a valid contract, then your client doesn't get any remedy for breach of contract either if you don't have a valid contract. The statute that applies here doesn't render the contract invalid. It says that it renders it unenforceable as to the non-licensed person doing the work. So does it, to me, that says it's not part of their prima facie case, but that it could be an affirmative defense that you did not raise.
Well, I mean, within the chapter 713 is, of course, the second statement, which says that the actual contract cannot be enforced in law or in equity.
Well, but only as
And-
to one party, right? It says it can't be enforced by the non-licensed contractor. So you still
Yes.
have a contract. There's a valid contract there, unless there's some other reason it's invalid, but it's just
Well-
not enforceable. So why would that be part of his prima facie case when all he has to show that it's a valid contract? And then you would have to come forward and say, sure, it might be a valid contract, but as a matter of law, you personally can't enforce it.
Well, I think that it goes a step further as far as you have to show that you actually have a valid remedy as well. It's not only a valid contract, but a valid remedy. Count one, of course, is an actual statutory lien where we place the burden completely upon the lienor to establish all the strict guidelines that they must meet. And one of which I would say is if you're coming forward to the court to say, I have the right to foreclose a lien for this work, then you also have to have a remedy that you can enforce. So whether this
That
is,
goes to whether they've stated a cause of action as opposed to an avoidance.
I would say so, Your Honor. I mean, you're essentially saying that that illegality takes no part in the discussion.
By the
I would
way,
say
this,
that-
by the way, oh, go ahead.
Let me ask this question. The defense or the enforcement mechanism of statute 489.128 sub 1 says, as a matter of public policy, the contract shall be enforceable. And obviously I didn't read the whole statute. There is a case, interestingly, out of this court in 1976, out of Charlotte County, Florida. It's a divorce case, but it says, first we note there was no plea among the husband's 10 affirmative defenses to the effect that the agreement was void or contrary to public policy for the reasons stated. And the court said basically that's a waiver of that affirmative defense. It's called Busat. And so that case would, at least in 76, suggest that this defense, void as public policy as defined by the statute, needed to be raised. So it kind of amplifies the concern that Judge Rosting-Yoakum had on this matter about where are we? And the trial judge ruled that it was waived, and there may be a legal basis for her ruling.
Well, again, I would say that you have the more strong statement by this in the statute that says that there is no remedy here. It cannot be enforced in law or in equity. And when you have especially count one, which is only statutorily based, it's the very statute they're invoking, 713, that allows them to foreclose. The question is, within that, how can you actually have a remedy that can be asserted that is not that is actually expressly forbidden by the statute?
All right, so you're saying it's
you could wait till the end of the trial and file a motion theoretically, as the court has it under advice, and say, oh, by the way, I just discovered this statute and now you should invalidate all the proceedings that went before and pay me my attorney fees for not knowing this, because it's a mechanics lien case.
Well,
Right.
I mean,
If your theory follows, it's just let me hide the ball for as long as possible. Is an argument could be made.
well, I think that the hiding the ball aspect of it goes to, where is the legislature and where's all the case law placing essentially the wrongdoing here and the penalty?
Well, there's no doubt this is arguably unlicensed practice of electrician. I'm not having a problem with that. The question is procedurally, under the rules of court, when do you have to notify the court and or the other party that this defense is available? And the concern is, the argument seems to be that I can wait, that it's not an affirmative defense. And candidly, the legislature doesn't say that it is or it isn't. They're silent. I understand that. But the rules of court suggest that I admit there's a contract here and I avoid it because it's unenforceable, would suggest that it may be an affirmative defense. And the rules of procedure suggest that if you don't raise an affirmative defense, it's deemed to waive. That's my concern. The legislature is silent. If had they spoken on this, I feel more comfortable, I guess is my part. So you've raised it, and I want to see, is the only argument I need to focus on is the language of the statute. How do I look at the rules, or does the statute trump the rules? I'm trying to make sure that I follow it all the way across, so that I'm not omitting any of your argument, your persuasive position.
Well, I mean, what I think is interesting here to note is that really the impact of the unlicensed electrical work impacts count 2, because the judge, of course, invalidated the lien based on multiple different reasons, on timeliness, amounts that were, of course, exaggerated on the face of the lien. The question is for the actual unlicensed electrical work becomes, does it spill over to count 2 now, and they cannot recover on, essentially on legal grounds, or maybe even count 3 on equitable grounds.
Well, count 3 is implied contract, quantum merit, huh? The legal fiction, right?
Yes, and of course,
And
the
I'm
court
sorry, I
found
cut
that
off
that
Judge
was,
Atkinson. And why don't you go ahead? I will give you some extra time since we're at 15, so Judge Atkinson can propound his question. You get a fair chance to respond.
So that goes my point. Okay, so you're leaving aside the lien count, you would have to argue successfully here on appeal that either A, it went to the illegality. No, sorry, I don't want to muddy the waters. The fact that the work was done without a license went to the essence of the contract to get rid of the entire agreement altogether, or you have to say that I can't recover, they can't recover damages for that portion of the work that was done unlicensed. But my question is, if the contract doesn't go away at all, then why can't they recover for work that was unlicensed? I mean, they did it. It's not like it's illegal, like it's a drug transaction or a prostitution or something.
well, I agree with that, Your Honor, that the question, of course, then becomes, I think, one of proof. And then we get into another major issue, which is that there was almost no proof in the prima facie case as to what amounts were owed, being able to distinguish between what charges were for what. The court even found that really their only fact witness on that issue.
But you have to prove to us today that your burden is to prove that there was not competent substantial evidence. You said it was confusing for the judge to have awarded damages and avoided awarding damages based on unlicensed electrical work.
Well, I mean, we would assert that, of course, there was no enforceable contract, whether by lien, by contract, by breach of contract, or by quantum merit. The court found no evidence at all supporting quantum merit, and then found that there was no definitive testimony or any evidence as to what was actually properly charged in the contract, except for
as a matter of law, the court couldn't have found quantum merit, because if she concludes there's an enforceable contract, then quantum merit, it's just out the door, right?
Yes, definitely. You have the either or.
Let me pause it here, since we've gone beyond the 16, and we'll stop here at 18, and I'll allow Mr. Clark to have an extra 2 minutes, and then my liberal arts major won't be unduly tested with mathematical equations. I appreciate your indulgence, and we'll call that 16 plus 2. And so you have Mr. Clark. Let me stop the clock here so you don't get there before your time. Sounds like that old wine commercial. We can start, please, Mr. Clark.
Brett Clark on behalf of Computer Guru LLC, the plaintiff below, and additionally, Robert O'Toole, who was not, but who at the last hour became a judgment debtor in this case.
At the last hour, wasn't he named?
He was not a plaintiff.
Yeah, okay, but you said at the last hour. I think it was a little before the last hour that he came on the scene.
The last hour was post-judgment. The Judge Porter had already entered her judgment, does not name him as a party to the case.
But he was named as a defendant.
He was in their pleadings.
And served with the counterclaim.
He was served,
Right, named
but
and served.
he was not a plaintiff, so he could not have been a counter defendant.
Well, shouldn't that have been brought up a little earlier than what you're saying? Or like, in other words, it seems like you're kind of, this is last minute on your part, not on the court's part.
Well, first of all, I wasn't.
I meant you. I mean the collective you, your client and
Yeah,
counsel at trial.
I understand, but see, the judge had entered a final judgment, and she did not name Robert O'Toole as a judgment debtor in her or as a plaintiff or a judgment creditor. He was not named at all in the judgment. That judgment became final, except for Clause J, which maybe we'll talk about that later. And then at the last minute, after we discussed, had a hearing on Clause J, and with no ruling by Judge Porter, at the 11th hour, a proposed judgment was given to her that names it reinserts him or inserts him as a judgment debtor in the case. And that's what I meant by the 11th hour. The proper procedure would have been for the defense to file a third-party complaint, name him, and explicitly set out what the grounds for his liability in the case were. And then you have a motion. The rules say that. The rules do not permit for a counterclaim against someone who is not.
Now you're bleeding back into the argument that should have been raised earlier by Mr. O'Toole. So let me ask you, and I may be confused here. I think there's two problems you're identifying. One problem is one that should have been raised in a motion to dismiss him as an improperly counterclaimed party, as opposed to a cross-claim or whatever. And then the next argument is that, well, we missed that. Even if we missed that opportunity to get him out early, there was a final judgment that only reserved jurisdiction to do certain things. And that was not, one of those things was not to add another counter defendant.
The liability of Robert O'Toole was never raised during the trial. There was no evidence presented that that would establish liability. And there was no finding in the judge's order.
It was an oral contract. So the court, we can presume the court thought, well, he contracted with them individually as well.
The problem in this case is that the rules of civil procedure were not followed. And had they been followed—
All right, which ones? Go for it.
Well, we'll start with the one where you can't file a counterclaim against—
No, let's just assume for my discussion that ship sailed when Mr. O'Toole didn't try to move, or whatever the proper counter defendant didn't move to get the principal out as a defendant.
Okay.
And then what? Let's focus on the other one.
Then it would behoove the defendant to present evidence showing that Robert O'Toole was liable, personally liable.
The counter plaintiff, yeah.
For any claims. I mean, it wasn't a counterclaim per se, but whatever you want to call it, this errant pleading against him, so they would have to present evidence showing—
Mr. O'Toole answered this errant pleading?
His lawyer wrote some goofy thing at the end of it saying, making a statement, and he signed it. But the pleading was on behalf of the plaintiff. And then so that's how she handled it. And as I may have mentioned, I was not the attorney at that time. I appeared post trial after the judgment was already entered, absolving him of any liability in the case. And the other thing about the pleadings, we have a court of law here. We need notice and an opportunity to be heard. That's the reason that we have pleadings that require you, for example, to raise the legality or illegality, or you want to say unenforceability of a contract in your pleadings, so that we know this is what you're arguing. and so that we can prepare for it, and so that the judge, I mean,
So illegality, let me ask you, so illegality in the rule is waived. Just focusing on the rule, is this illegality? Is this an illegal contract, or is this just unenforceable because the individual who's suing on the contract was not licensed to perform the work for which the parties contracted?
if you can call it illegality, it is definitely an avoidance. The case, which I'm surprised that I missed this one, that Judge Casanueva, I don't know why I didn't find this one, but it's an avoidance. In that case, they called it an affirmative defense. So whatever you want to call it, my opinion is, yeah, he's saying he did the work.
I had an advantage you
licensed.
didn't have. In 1976, I practiced law in Charlotte County.
Okay, so you were there, maybe.
I was probably in the building somewhere.
I missed it. I didn't find it. But in any event, you got to set these things up in the pleading so that we know what we're trying. And this thing of hiding the ball, and then all of a sudden you're in the middle of a trial. And in the case of Robert O'Toole's liability, they didn't even raise it during the trial. It wasn't until after the trial, and counsel submitted a proposed judgment to Judge Porter saying that he was liable for breach of contract. And the judge did not go with that. She did not do that. And she purposefully wrote a final judgment that excised Robert O'Toole as a party to the case. Yeah, I think that's the way things should go. It's due process of law. You know what you're trying. You have a pretrial stipulation. In this case, neither of these two issues were raised. And so that's when you do things like that. My personal opinion, I think
it was raised, it just wasn't pled. The issue of the unlicensed nature of the work. Well,
Right.
Let me ask you this. So let's okay. So the unlicensed work. Let's assume for a second we decided it did not go to either A, it was waived because it wasn't pled as an affirmative defense, or B, it didn't go to the essence of the contract, so it could be severed. Now, is there on appeal, is there an issue about going to not your cross appeal, but the appeal? Is it possible for us to reverse by finding fault in the trial court's award of damages for unlicensed work? Which is different than saying that the trial court should have just not enforced the contract at all.
Now you're getting into the weeds of which part of this is illegal or which is unlicensed and therefore not allowable, and which were not. And I think there's a lot of murkiness here in this record. And Mr. Glausier's position at the trial and here, which are you talking about? Because there was electrical work that was done. There's evidence of that. There was electrical work was done by a electrical contractor. That was invoice number 3. I think it's on page 3 of our brief. And that is the part that needs to be licensed. But that ultimately, number one, was not part of the lien because they pay for it. The defendant very quickly paid for the invoice number 3. So technically, it was not part of the lien. You can't say it's part of the lien, but it was part of the when you look at the case as a whole, the plaintiff's position was, here are 10 invoices, and this establishes a course of conduct, and there was a contract arising from them, and the defense essentially agrees to that is true. So I hope I'm answering your question. It's just, are we to look at each individual invoice and say which one required electrical work and which did not? And
so what are your argument? So you're saying, so we have, when I read the brief of the appellant, and he'll have a chance to respond, it doesn't very explicitly say, well, let me put it this way. If we say A, that the unenforceability was waived because it wasn't pled, and B, you can't throw out the entire contract because it doesn't go to the essence, so it's severable. Could we look in the record and say, well, some of what was awarded as either for either count, the lien count or the breach count, was for unlicensed work. A, is that adequately argued on appeal by the appellant? And B, if it was, could we do that if the contract wasn't thrown out?
That gets back to the question, the weeds that I'm trying to avoid is what is considered things that are require an electrical.
Well, now it sounds like you're saying that even if we could, we can't do it in this appeal because the record, there was enough in the record to support a trial court's finding that what was awarded was attributable work that was not unlicensed.
You're gonna have to rephrase that.
All right. Well, I'd have to remember what I said in order to rephrase it.
I think we're getting the distinguishing and awards of damage. If the court were to conclude that the statute was not an affirmative defense and it barred recovery, would it only bar recovery of damages for work that required a license, and the plaintiff could arguably recover damages for work that did not require him to be licensed? And by the way, I use the word license within the meaning of the statute, which talks about licensed and registered, as Mr. Glosser brought out in his cross-examination of Mr. O'Toole, because he asked both, and that's the language in the statute. So if he did work that didn't require him to register with the state or to be licensed with the state, did the trial court differentiate that so we might know what it is?
She did not. She did not, because she ruled that it was waived. The issue was waived, so she didn't get into any of these issues. So we can't say that Judge Porter was concluding anything regarding that question. But then if we're going to go down that road,
Let me ask you then another question about the statute and see what your view is. On 489.516, subparagraph 1, it begins with the language, any person who desires to engage in electrical alarm contracting on a statewide basis. Obviously, for that to work, arguably the response from the defendant would be to show that he had to be certified, which means he wanted to be engaged in statewide work. The next sentence, or the next part of it, says, any person who desires to engage in contracting on other than a statewide basis shall be registered. Now, subparagraph 2 is clear. No person not certified or registered shall engage in business. So with regard to that statute, and 489.128, it talks about an unlicensed contractor being barred. Does the phrase unlicensed contractor apply to both someone who requires certification or someone who must register? Does it encompass both terms?
I don't know. I didn't really consider that.
Okay.
But my reading of that statute was that he who holds himself out as an electrical contractor is subject to licensure, and that's what.
That's the concern I have, because if I'm to be governed by the text of the statute, the legislature has made it pretty clear what it wants you to do. If you are going to engage in a statewide practice where maybe you have to, where you might harm more people, you have to have a particular license. If you're going to be less than that, maybe in just Charlotte County, you could register, but you have to do one or the other. You can't do neither, it seems to be.
Okay, but doesn't this beg the question, the two cases, the Maztec case?
Well, I don't know, because I don't know what's been preserved with the trial court too, and this may just be a hunt of my own.
Okay.
But I was trying to labor through, what does this statute mean and who does it apply to before I decide whether it's unenforceable?
I think it means that the cameras installed there at the second DCA with the wires attached to them did not require a electrical contractor to do that work, because it's not what we think of as as the case.
Well, we'll be careful because we just rent these premises from Stetson. We didn't hire anyone.
Okay, well, I'll bring that up with the dean and find out if you, but the point being, and I'm being a little facetious, is that you really, to put up cameras, put a Category 5 cable, which I have down there, and I'm going to confess, I did not hire an electrical contractor to put the Category 5
The
cable.
question is, on this record, if Mr. O'Toole or the CompuGuru, the computer guru, is to sustain its claim, and and there was questions raised about, I told them I was an electrician, they asked me to do it, and I did it, and he wanted to make sure he got some damages award, wouldn't he need to show that this work did require him to be licensed or to be an electrician?
He's only talking about invoice number 3.
Okay.
That work on an invoice number 3 was done by an electrical contractor. And frankly, on this record, there's no proof that he wasn't licensed. There's no proof that he wasn't licensed. That it goes to number 3 where
Hey,
Well, he was asked that whether he was licensed.
Mr. O'Toole testified he wasn't licensed.
Yeah, he was asked.
no, he hired a electrical contractor. And it is in the brief. I referred to the record, and in fact, the defense's witness
No,
referred to.
I think the statement that you made was, he was, it was not established that he wasn't unlicensed.
Right,
I mean,
because
Mr. O'Toole.
because
Well,
most
Mr.
people,
O'Toole testified, on record, I think, page 95 of the trial transcript. Question: Are you licensed by the state of Florida for anything? No. Is Computer Guru? No.
Yeah.
Are
You're
you
talking about
a
another
registered electrical contractor?
individual,
No.
correct?
he is not licensed, but he hired an electrical contractor to do the electrical work.
Okay.
That's what happened in the case, and he names the person who did the electrical work because everybody else out here in the real world knows that hooking a camera to a computer is not electrical work, but messing with the fuse box is. That is the work that he hired the electrical contractor to come in and do. And he hired that person. That person did it. That's invoice number 3. And the evidence, there's no contradictory evidence that other than that fact that he hired an electrical contractor. We don't know if he was licensed or not, but he did that specific work for which one would imagine, yeah, you got to have electrician do that because he's working with the fuse box. But as far as hooking your computer to a camera, which I have done here, and again, I'm not an electrical contractor, but it seems to be okay. And most people would not find that to be electrical work that requires a license. So the plaintiff was being very honest, and I'm not licensed to do that because no one asked him, well, are you required to be licensed? And he might have said, no, I don't think so. I don't know. I don't know that I am. I don't think so. But so that's why that's an important distinction in this case. And if we're going down the road of starting to open up this whole thing, and now we're going to start trying the case on this issue of illegality or unenforceability because of the licensure issues, then we have to get into the Sylvester case and the Mastertech case. And you notice there was a dissent, if I recall, in the Mastertech case. Where the judge, Salter, I think his name was, says that the electrical code does not require you to do this kind of work. And in that case, it was satellite dishes and wires coming down, low voltage carrying wires. And he says that voice and data over a cable is not electrical work. It doesn't require an electrician's license to do it. So, I mean, the judge didn't reach any of these issues, and she found that it was waived. It wasn't raised before the trial. It should have been, but it wasn't. And she's, unless the court can find some legal reason that she was completely out of bounds in making that decision, then I think the decision has to stand. And are we going to have time to talk about some of the other issues?
You have 2 minutes left.
2 minutes. There was a comment made by counsel about the lien. Do I get a separate argument for my cross appeal?
Well, y'all had the same amount of time, and I have to confess I didn't ask you if you wanted time for rebuttal, but I think you're into your time.
I'm at the end of my time, but if there's any last second questions, because there's a lot of issues involved there on our cross appeal.
If there's any points you want to bring up that you want us to make particular close attention to, now might be a wise time to do that.
Okay, the breach of contract damages assessed against my client. The law is that you have to establish a causal link between the breach that she found and the damages that were incurred. And I only have a few seconds left. In the reply brief, I likened it to the Paulscraft case. How often can you get a chance to cite Paulscraft, especially in a breach of contract case? And the point being, breach of contract in the air, so to speak, will not do. You have to show a link between what the bad thing that Computer Guru did and the damages that they claim, which is like travel expenses, meals, and the replacement of equipment that was damaged by a bolt of lightning. Assuming that that was because it was damaged by lightning, that is a breach of contract, which, by the way, the Judge Porter did not find. So that's
Okay.
I'm out of
Why
time.
don't I reserve the rest of your time, since you should have rebuttal on your count, on your cross appeal, so that if Mr. Glazier goes into it, you still have time to respond.
I would very much appreciate that.
It will be done. Mr. Glazier, the floor is yours, and you still have your 4.
Thank you, Your Honor. I do want to correct some inaccuracies that were brought about. I think that we've explained them in our reply brief, but want to be clear here that there's a lot of hay made about the lightning, and yet the timing of the lightning issue doesn't even pan out. The parties had agreed to a finish date in June of 2017. The lightning doesn't happen until September. After a time that Mr. O'Toole had actually confirmed by text that the project was 99.9% done. This is not a case about weather damage. It's not a case about lightning. It is a case about everything that did not occur as promised in the original contract. The court does a good job about saying they did not get the cameras they wanted. They didn't get the sign-in information they wanted. They didn't get the training they wanted. They didn't get the warranty they wanted. They didn't get the anything installed the way they wanted. And that was all well before September of 2017 when the lightning happened. I also want to point out that Judge Porter did, in her final judgment, award damages against Mr. O'Toole personally. She does name him as a partner because he filed an answer in the case. Paragraph 9 of her findings says the defendant was damaged by plaintiffs, and that's a plural possessive, failure to perform the contract with defendant. And I would agree with the court that since we had an oral contract here that was memorialized by text messages, emails, and invoices, that the court could very well have concluded that this was one that was done both in a corporate capacity and an individual capacity. I also want to point out that there's a lot of focus put on the invoices that were sent to the appellant. And that's apparently the documentation of the contract. When the court, Mr. O'Toole, and even in the briefs themselves admit that O'Toole kept horrible records of the transactions, could not testify as to what was owed, could not identify the charges that were on the invoices at trial. So we have a course of litigation for 16 months. And this is important to note. They filed an amended claim of lien. And then when trial came around, they abandoned their amended claim of lien and went to the original claim of lien.
They withdrew it, right?
They did. And the question is, once you've
And
amended a
Mr.
lien.
O'Toole verified the withdrawal on his testimony.
Yes, Your Honor. And, the amounts are bouncing back and forth. And then they had full opportunity. Maybe the argument can be made that the illegality was sprung on them, even though I don't think that's true. They had a full opportunity to present their breach of contract and lien foreclosure remedies and could not testify as to the amounts that were owed. can't make an argument here that the judge did not afford them the opportunity to provide substantial evidence in support of what charges were what, how the payments were applied, which invoices were paid off.
Honestly, how does that help you and in support of what issue on appeal? And that dovetails crudely, I'll admit, into my other point that I've tried to make and done so inarticulately. For instance, on the issue of the non-licensure, the trial court seemed to consider it an all or nothing argument, and it seems on appeal that you've argued it as an all or nothing argument. In other words, if it was not waived by not being pleasant for instance, and if it doesn't go to the essence of the contract, then what does it matter what was or was not done without a license, without the proper license? And you have not in your answer brief delineated what essentially that you were charged and the plaintiff was awarded either as foreclosure on a lien or a breach of contract for work done, which work done was done for unlicensed work and which wasn't, and whether that even could be a reversible error.
Well, my response to that would be, again, I think that it determines count 2 completely, and whether there is an offset essentially here of the $15,000 that the trial court believed was owed to the plaintiff, and then the $9,000 that was owed to the defendant. But secondarily, it also gets the sloppy record keeping, the overcharging of amounts. That gets to what we believe is the second issue, which is that the appellant prevailed completely on count 1, which was the only count that permitted an award of attorney's fees, and that therefore, since the lien foreclosure was dismissed, the lien was discharged, the court found that there were exaggerated amounts on the lien. There was double charging for equipment. She actually found that.
Doesn't she have to find willfulness? And as a finding of poor record keeping or negligence or something like that, that's not willfulness, right?
So the statute though contemplates gross and negligent record keeping. The language is actually willful and gross negligence as to amount to a willful exist. Yes, and so we would say here that when you have a final payment affidavit that's one number, a claim of lien that's another number, an amended claim of lien that's another number, and then you come to trial 23 months later and still can't prove the amounts or testify to the amounts, then you're double charging, and then you're adding repair costs and storm damage assessment amounts and video recoverage fees, as well as all these different services you never delivered. And by the way, your invoices say that final payment is due only upon completion, and yet you're now demanding 100% prior to completion. All this wraps into itself to be to what we would say is entitlement to attorney's fees. And again,
I think that'll have to be the last word. We've gone way past the 4.
Okay, I apologize. Thank you.
No, that was my job to let you know, not yours. And you ended on an emphatic point. I thought that was a good spot. We'll go to Mr. Clark. Mr. Clark, you have 3 minutes left.
Okay, 3 minutes. Not to belabor not to belabor this any more than we already have. At one point in the final judgment, the Judge Porter puts an S at the end of the word plaintiff, whereas throughout the rest of it, it does not. And that is a very thin read because there was an S in the back of plaintiff in one sentence of a judgment to say that somehow constitutes Robert O'Toole being added as a judgment debtor in the case.
In the amended suit filed by the counter plaintiff, counsel articulates Mr. O'Toole, I think it was in paragraph 7, as being a defendant, and a great number of the wherefore clauses request damages against him. And then we have an answer that Mr. O'Toole files to that and says, I deny all allegations against me and demand strict proof. He has no other defenses put forward. Sounds like he may have waived them.
Well, he didn't have an opportunity to file a pleading directed at him. And that gets back to the point that I'm saying.
I don't understand that statement.
He had the opportunity to file something.
He's not a counter defendant because he's not a plaintiff. Only a plaintiff can be a counter
Well,
defendant.
can't he,
The
doesn't he have a
rules
duty
say-
to bring it to the court?
The rules say, well, but it's incumbent upon the defendant to file a third-party complaint and to serve him with that so that this person sees what is directed at that person and they can respond. Instead, we did this other weird procedure. And yeah, it's true that his previous counsel maybe should have filed a motion to strike it or something.
Well, you don't have to belabor the point. You only got a minute left.
Okay, only have 1 minute. There's the judge found that the reason that the judge dismissed the lien case is because she found it was untimely. There was none of these other things that are being alleged here. She's found that it was untimely, and that's the reason she discharged it. She didn't discharge it because it was fraudulent. Judge never found that it was fraudulent or any of these other issues. That is the only reason that the lien count was dismissed. And as far as the prevailing party, we prevailed in the case, but we're not arguing that we're prevailing and so we get our lawyer fees. Because we know the judge, if things are as they stand right now, Judge Porter was within her rights to say that neither party was prevailing, and the law is pretty clear on that. And it's well briefed in this case. So I'm going to yield the balance of my time.
Thank you. We
Probably have like
appreciate
10
all 3 seconds. And with that, we will conclude today's presentation. Thank you all for the job you did today. This was a interesting and a challenging one to work through. And please stay well.